All right, so the Marriages Amendment Bill passed in the lower house, and I wanted to take some time to consider the significance of the changes that are being introduced to our marriages regime. I will not dwell on the reports suggesting that there is now a new law in terms of which bride price will no longer be a legal requirement for registration of African customary marriages, because that is more or less the position in Zimbabwe since the 80s. There is really nothing new there. Customary marriages have always been understood to be an agreement between the families, whether those families agree for a transference of certain wealth or money. That's always been a matter between the families. So, really, nothing to see there. There's nothing new in terms of that particular claim. I'm focusing on something different altogether, and in order for us to follow the discussion together, I'm going to have to just give background information. So we have three marriage regimes in Zimbabwe. More or less, we've got the registered customary marriages, the unregistered customary law unions, and we have the civil marriages. And the reason we have this plurality of marriages is because of our colonial history. Every other country with a colonial history has also has this diversity of marriages, because when the colonizers came, they had their European law and we had our African customary law, or basically African law, and the colonizers did not want those to mix. So European law applied, and this is what we've then understood now as general law, and then African law also applied, and then this is what we call African customary law. So we've always had those different types of marriages, at least since our colonization. But what's interesting for our purposes is the fact that the civil marriage is monogamous, and by that I mean it is, based on faithfulness between two partners, whereas the African marriages are potentially polygamous. So one man, one partner can have more than one other partner, and this is an important consideration because a lot of people make choices of regime of marriages in order to protect themselves. Particularly, I would say many women opt for the civil marriage because they want to ensure that there are certain laws in place to protect their monogamous conceptualizing of their union. So if you're married if you've got a civil marriage, then you can sue the other party for adultery, but there's a criminal law of bigamy in terms of which a party engaging in another marriage can actually be arrested. So you are well protected, unlike in the context of customary marriages. Now, what this amendment does is to introduce a civil partnership. So it still restates the fact that, okay, civil marriage, that's monogamous, customary is potentially polygamous, but then it introduces a civil partnership. And last time the uproar was over the fact that these civil partnerships, it's stated in section 4 subclause 5 that the civil partnership persisted whether or not one or both persons were legally married to someone else. So this was a new law which was really cutting back at that idea of monogamy, that okay, you're not allowed to marry anyone else, but you can have a civil partnership. And so the government said, okay, we understand. We did not mean to offend or to intrude on the sanctity of the monogamy of civil marriages or marriage in general. Therefore, we are reconsidering this. And they came back. So on 28 May 2020, the Minister of Justice then in Parliament says, okay, we've removed married people from the provision regarding civil partnerships. We've removed the old 40 subsection 5 because of the feedback we got, and we've introduced the new one. Now, I want to go through that new provision with you in order to assess the extent to which the minister's claims are accurate. Now, the new, as I said before, the old 40 subsection 5 was just one sentence. It applies the civil partnership whether the other person is married or not. Now, it is at least 3 subclause. It's very long now. It says in 5A that a civil partnership exists where both of the partners are not married civilly or customarily to anyone else. And I'll submit to you that if this provision ended right here, then what the minister is saying would be entirely accurate. But it continues. Or where both partners were not married civilly or customarily to anyone else, and subsequently either one of them married someone else civilly or customarily. So we are back exactly where we began. So you can have your civil partnership as long as your marriage happens subsequent to the establishment of what the court will call a civil partnership. It's important to recall as we're having this discussion that a civil partnership is something that is decided by a court. This is why it's a strange kind of marriage. I've written about this. I'll include a link to the blog in the description of this video. Marriage was always understood to be when people consent to an institution and then either come before the state for a civil marriage, or you come before your families in terms of customary marriages. But then now a court will be given the power to look into certain factors and say, okay, this relationship is over, but because they meet certain criteria, these people have got certain rights and obligations that normally accrue to married people, which will apply in the context of a civil partnership. And that is in respect of division of assets, maintenance, and custody of children, for instance. So when that relationship ends, a court will be able to say, okay, this was a civil partnership, even if one of them is married or not. In terms of this subsection, it will still subsist. In terms of 5b, as long as that marriage happens after the civil partnership began. But then it doesn't end there, because it says if the marriage happens subsequent to the establishment of the civil partnership, then all that can be divided in terms of assets is what happened before the marriage. But then there's a proviso. If you show that what was bought after was also jointly contributed by the civil partner, then you can also access that. But then it doesn't end there either. Then it is subsection C, where one of the partners is married civilly to someone else and marries customarily the other partner. So this is now, it doesn't actually have to be subsequent. If it's not subsequent, you're also covered by C. So my understanding of this amendment is, and part of the amendment, by the way, is not very easy to understand, is simply because of the choices of diction and grammatical constructions that have been chosen. But we're back where we started. It will not matter really whether the other person is married or not for a civil partnership to persist, for a person to be able to accrue certain rights. What they've simply done is broken down certain criteria in terms of which, well, if the other person is married, you have to actually show that, for instance, the assets that you are claiming you either contributed to or they were bought individually by the one partner, not jointly by the other person who is married. So they have not removed married people from the ambit of people who are covered by civil partnerships. What they have sought to do is to simply address the material and not moral concerns of civil partnerships. What they've done is to say, okay, we'll provide factors in terms of which a court will really look to ensure that the assets that are being distributed are not the assets of the person who was properly married or not involved in the civil partnership. So they've really turned a blind eye to what everyone complained about regarding what are the moral implications of this provision, and they are seeking to only address the material aspects. And as I've said, this has already passed the lower house. It's now before the Senate, where conceivably it's going to pass as well, and this will be the new law of our land.